screen is black, yes, but we back, yes, doing it big. Nevertheless, nonetheless, we blessed. Trying to get unstressed, distressed, distress. We not distressed, we chilling on the max. Gonna press play, man. All right, let's go.
Information purposes only.
Move on.
Resources presentation or legal options of any specific facts or circumstances.
All right,
It is intended for general informational purposes only. Please consult legal counsel if you have questions about your own situation. Let me also introduce Paychex, who has more than 40 years of industry years of experience and provides payroll processing for 567,000 businesses. Paychex also delivers Fortune 500 employee benefit services, human resource outsourcing solutions, workers' compensation, and health insurance through our Paychex Insurance Agency, as well as safety and loss control services. Our agenda for today is we will define discrimination and protected classes, discuss harassment, including sexual harassment, review examples of potentially unlawful conduct, explain employer liability, examine key elements of a non-harassment program, outline complaint procedures, identify key elements of investigation procedures, and discuss the prohibition against retaliation. What's the big deal? Everyone deserves to feel comfortable at work and be treated professionally with regard to sex, race, religion, color, national origin, age, disability, or any other protected class. Harassment is a serious matter that can affect not only the victim, but also the workplace environment. Unfortunately, subtle forms of harassment might not always be recognizable. And often people don't know how to handle it when it occurs. Defining discrimination. The exact definition of unlawful discrimination may differ depending on the enforcement agency and the courts. However, discrimination in employment may be broadly defined as treating a member of a protected class, which could be an applicant or an employee, less favorably than others because of the person's membership in that group. There are several types of discrimination, such as differential treatment, unintentional discrimination, and harassment. Non-discrimination principles apply to all aspects of the employment relationship. Training, promotions, work assignments, transfers, compensation, layoff, discipline, and or discharge, including constructive discharge. Working conditions. It is important to provide a work environment where employees do not feel intimidated, unfairly treated, or segregated from others based on membership in a protected class, such as race, color, religion, sex, age, national origin, etc. Working conditions generally refers to the workplace environment. It's important to provide a work environment where employees do not feel intimidated, unfairly treated, or segregated from others based on membership. in a protected class, such as race, color, religion, sex, age, national origin, etc. When working conditions become so intolerable due to some unlawful reason, including harassment, that an employee feels compelled to resign, he or she may have a claim of constructive discharge. Now, constructive discharge is based on the reasonable person standard. A reasonable person would feel compelled to resign their employment rather than continue under those working conditions. Now, discrimination, including harassment, is unlawful when based on a protected class, as previously mentioned. It can not only affect the victim, but also the workplace environment, leading to lost productivity, decreased morale, group conflict, damaged careers, and reputational risks for the company. Protected classes. Federal law prohibits harassment and discrimination in employment based on the Equal Employment Opportunity Commission is the federal agency that oversees enforcement of some of the key federal anti-discrimination laws, including those prohibiting harassment. Some of the laws enforced by the EEOC include, but are not limited to, Title VII of the Civil Rights Act of 1964, which prohibits discrimination based on race, color, religion, national origin, or sex. This law applies to employers with 15 or more employees. The Pregnancy Discrimination Act amended Title VII, making it illegal to discriminate against women because of pregnancy, childbirth, or related medical condition. The Age Discrimination in Employment Act, also known as the ADEA, which prohibits discrimination based on age 40 or over. This law applies to employers with 20 or more employees. The Americans with Disability Act, also known as ADA, which prohibits discrimination based on physical or mental disabilities. This law applies to employers with 15 or more employees. The Genetic Information Non-Discrimination Act, which is also known as GINA, which prohibits discrimination based on genetic information. This law applies to employers with 15 or more employees. Federal law prohibits harassment and discrimination in employment based on age, 40 and over, disability, genetic information, national origin, pregnancy, race, color, religion, sex, gender, or veteran status. Your state and or local anti-discrimination laws may include additional protected classes. These protected classes include age, 40 and over, disability, genetic information, national origin, pregnancy, race, color, religion, sex, gender, or veteran status. Please note that state and or local anti-discrimination laws may include additional protected classes. Discrimination and harassment. Harassment is a form of discrimination based on a protected class that is prohibited by federal, state, or local laws. Therefore, when we discuss harassment, it is necessary to understand discrimination. Both discrimination and harassment can be unlawful. Each can affect not only the victim, but also the workplace environment, leading to group conflict, damaged careers, and public embarrassment for the company. The effect on the workplace harassment is shared, but how are discrimination and harassment different? Let's continue by defining harassment. Defining harassment. The EEOC defines harassment as a form of employment discrimination that can violate Title VII of the Civil Rights Act of 1964 The Age Discrimination in Employment Act of 1967, also known as ADEA, and or the Americans with Disability Act of 1990, also known as the ADA. Unlawful harassment is unwelcome conduct based on a protected class, where enduring the offensive conduct becomes a condition of continued employment, or the conduct is so severe or pervasive as to create a work environment that a reasonable person would consider intimidating, hostile, or abusive. Defining harassment continues. Anti-discrimination laws also prohibit retaliation against individuals for filing a discrimination charge, testifying, or participating in any way in an investigation, proceeding, or lawsuit under these laws, or opposing employment practices that they reasonably believe discriminate against individuals in violation of these laws. When it comes to harassment, it is important to note that while illegal harassment is a form of discrimination, not all discrimination claims are necessarily considered harassment. Harassment can violate the law when unwelcome behavior occurs and the behavior is based on a protected class. However, harassment cases are case-specific, and one unwelcome comment may not always rise to the level of harassment. Let's define sexual harassment. Let's shift our focus from harassment in general to sexual harassment. Due to the prevalence of allegations of sexual harassment, we'll cover the topic of sexual harassment in more detail. The EEOC has provided guidelines for defining sexual harassment. Sexual harassment is defined as unwelcome sexual advances, requests for sexual favors, or other verbal or physical conduct of a sexual nature when the conduct explicitly or implicitly affects an individual's employment, unreasonably interferes with an individual's work performance, or an individual creates an intimidating, hostile, or offensive work environment. Types of sexual harassment include quid pro quo and a hostile work environment. Quid pro quo sexual harassment is when sexual favors are demanded in return for a tangible job benefit. An example, a promotion, or when the employee is threatened with discharge, demotion, or some detrimental impact on his employment for failing to meet a sexual request. This type of sexual harassment generally involves a supervisor, manager, or other person in authority. The hostile work environment can be described as an intimidating, hostile, or offensive work environment, where an employee is subjected to unwelcome gender-based sexual conduct that is pervasive or severe enough to alter the terms or condition of the person's employment. The more severe the conduct, the less frequently it likely has to occur to be considered a hostile environment. Unwelcome verbal or physical conduct based on gender can also be the basis of a claim of sexual harassment. Conduct that may be unlawful. Unlawful harassment may be based on sex, race, religion, color, national origin, age, disability, or any other protected class at the federal, state, or local level. These are a few examples of conduct that may be considered unlawful. Again, this is not an all-inclusive list. Offensive jokes, pictures, or comments. Rude treatment of women or men because of gender, including same-sex harassment. Unwanted imitations, notes, and/or flirtations. Sex as an implied condition for promotion. Harassment after breakup of a relationship between employees. Now I will turn it over to my colleague, Donna, who will cover employee liability as well as the policy process. Sorry.
Thank you, Lowell. So what I'm going to discuss are the federal laws, the employer's responsibilities, affirmative defense, constructive discharge, and individual liability. Under the federal anti-discrimination statute, whenever unlawful harassment by a supervisor or manager results in a tangible employment action against the victim, for example, a demotion, a termination, etc., the employer may be held strictly liable for damages to the harassed employee. That is, employers may be held liable for harassment by a supervisor or manager, resulting in a tangible employment action, even if the company did not know or had no reason to know about the harassment. Hostile work environment harassment by a coworker may result in employer liability if the employer knew or should have known the harassment was occurring and failed to take reasonable steps to prevent or stop the harassment. Also note that supervisors and managers may be held individually liable by a court or under state law. Employers' responsibilities. So although employers can sometimes be held liable for unlawful harassment, even if they did not know about it, in many instances, the employer's efforts to educate its employees and find out about and correct harassing conduct may result in the employer not being held liable or may minimize the damages to which a harassed employee may be entitled. That means the employer should have a well-disseminated and effective no harassment policy, including effective complaint reporting and investigation procedures, and educate employees on the policy. If an investigation reveals inappropriate conduct, the employer must act reasonably and promptly to put an end to it and prevent it from recurring. Affirmative defense. When no tangible employment action is taken against an alleged victim of harassment, a defending employer may raise an affirmative defense to liability or damages. The two necessary elements to establishing an affirmative defense are the employer exercised reasonable care to prevent and promptly correct any harassing behavior, and the alleged victim unreasonably failed to take advantage of any preventative or corrective opportunities provided by the employer or to otherwise avoid harm. Constructive discharge, as previously defined, when working conditions become so intolerable due to some unlawful reason, including harassment, that an employee feels compelled to resign, he or she may have a claim of constructive discharge. Constructive discharge is based on the reasonable person's standard. A reasonable person would feel compelled to resign their employment rather than continue under those working conditions. Employers may raise the affirmative defense to constructive discharge harassment claims if the employer had clearly communicated effective complaint procedures and the employee failed to use the employer's internal complaint procedures, provided that no tangible employment action was taken against the employee. Individual liability. So although Title VII of the Civil Rights Act applies to employers with 15 or more employees, some courts have held that individual supervisors may be held liable in harassment claims because he or she is acting as an agent of the employer. State anti-discrimination laws may extend to supervisors and result in individual liability for harassment claims. What are the remedies for victims of harassment? Employees who feel they have been subjected to harassment in the workplace may take any of the following steps to remedy the situation. Following the company's internal procedures and report the act immediately to one of the persons indicated in the company's no harassment policy. They may contact the Equal Employment Opportunity Commission or file a complaint with the appropriate state agency. Potential remedies under the applicable laws available to victims of discrimination, including harassment, include back pay and benefits, hiring or reinstatement, policy changes, training, reasonable accommodation, recovery of attorney's fees, expert witness fees, and court costs, compensatory damages, including reimbursement for out-of-pocket expenses or for any emotional harm suffered, punitive damages, and liquidated damages equal to the amount of back pay awarded. Now we're going to look at some key elements of a non-harassment program. Prevention may be the best tool to eliminate harassment in the workplace. Managers and supervisors should take steps necessary to prevent harassment from occurring by making sure they clearly communicate to employees that harassment will not be tolerated. They can do so by posting the required state and federal posters, distributing required brochures, communicating their company's no harassment policy from the employee handbook, providing harassment training to employees, communicating and following an effective complaint or grievance process, and taking immediate and appropriate action when they witness inappropriate behavior or an employee complains. Employers must comply with federal and state laws and/or regulations. Failure to display required federal and state labor postings may result in fines. Managers and supervisors can assist employers by making sure that notices of employee rights are posted in a conspicuous and accessible place where they can be seen by both applicants and employees in all company locations. Promise to take prompt corrective action if harassment allegations are proven, assuring no retaliation. Emphasizing sound management practices. Managers should be trained in and adhere to sound management practices. Whether based on a protected category or not, workplace conduct that is otherwise malicious, abusive, hostile, or offensive should not be permitted. Abusive conduct, whether by a manager or a coworker, may include repeated verbal abuse, derogatory remarks, insults, epithets, or physical conduct that a reasonable person would find threatening, intimidating, or humiliating. Supervisor and management training. As a manager or supervisor, you should attend training on the statutory provisions prohibiting harassment in the workplace, how to detect harassment, appropriate actions for preventing and remedying misconduct, and your responsibility for reporting and or addressing harassment in the workplace. If you, as a manager or supervisor, are accused of unlawful harassment, you may not keep it to yourself or decide laws prohibiting harassment in the workplace, how to recognize harassment, and the employee's responsibility to report harassment if it occurs. Written policies. Know your company's policies setting forth its commitment to eliminate all types of unlawful harassment. As a manager or supervisor, you should be enforcing the policy. Employee communication. Effectively communicate the policy to all employees on a regular basis. This should include putting the policy in your employee handbook, distributing a copy of the policy to new employees, and redistributing the policy to existing employees on an annual basis. Open door policy. It is important to promote upward communication so that employees feel comfortable coming forward with complaints. Limiting employer liability. By taking reasonable care to prevent and eliminate harassment in the workplace, you and your company may be more likely to avoid claims and/or limit liability for damages. To help avoid or minimize liability in harassment claims, consider the following. Understand the value of having effective, strongly worded policies prohibiting all types of workplace harassment, including sexual harassment and harassment based on any other legally protected class. Distribute, either in electronic or hard copy format, a copy of the company's no harassment policy to all employees and obtain signed hard copy or electronic acknowledgement of receipts from them. Redistribute the policy on a regular basis or more frequently if changes are made to it, and provide non-harassment training for all employees. Complaint procedures. A clearly communicated formal complaint procedure is essential to help ensure that employee issues are handled consistently, confidentially, and promptly. Managers and supervisors should have an open door policy where employees feel comfortable bringing complaints to management's attention. Know who should receive complaints. Employees who believe they have been a victim of harassment or know about harassment occurring in the workplace should report the conduct immediately as directed in the company's no harassment policy. As a manager or supervisor, if you receive a complaint, you should know who else in your organization needs to be notified of the situation. For example, your human resources department. Allow complaints to be verbal or written. If an employee brings a verbal complaint, you may ask the employee to put the complaint in writing, but don't mandate it. If the employee does not put the complaint in writing, document the complaint and ask the employee to sign verifying the information is accurate. Not having the complaint in writing does not dismiss your obligation to take action, nor should it cause you to take the complaint less seriously. Conduct prompt, thorough, and impartial investigations of all harassment complaints in accordance with your company's no harassment policy. Employers can be held liable for failing to investigate a complaint of harassment, but this doesn't mean that you personally should investigate every complaint. Do not retaliate or allow others to retaliate against the complainant. If you receive a complaint, do not retaliate against the employee. Assure the employee that he or she will not be retaliated against for filing a complaint of harassment in good faith or for participating in a harassment investigation. Take prompt corrective action if you receive a complaint. Follow your company's procedures, and managers or supervisors who know of harassment and fail to take appropriate steps may be subject to disciplinary action under the company's policy. Taking a complaint from an alleged victim of harassment can be stressful at times. It is important that you remain neutral, make the employee feel as comfortable as possible, let him or her speak, and ask the right questions. The following are some basic questions you can ask to gather the initial facts. What happened? Who said what? Where did this take place? When did it happen? What was your response? Who else was present? And is there anything else you would like to tell me? Assure the employee that there will be no retaliation for having brought the complaint or participating in an investigation. Employers who know of harassment or should know and fail to take appropriate steps to prevent it from continuing may be held liable. The key elements of investigation procedures. Your company is obligated to conduct prompt, thorough, and objective investigations of all harassment complaints. The extent of the investigation may vary depending on the nature of the complaint. You should be aware of the key elements of the investigation process. Know who the appropriate person is to conduct an investigation. Your company should have a designated point person who will coordinate investigations and appoint the appropriate investigator. If you are a designated investigator, you will be trained in conducting effective workplace investigations. Ensure promptness. Take appropriate steps so that investigations can begin as soon as possible after a complaint is received, generally within 2 business days. Keep the complainant advised of progress to assure them that their complaint is not being ignored without disclosing details of the investigation in progress. Be fair, thorough, and considerate. Investigators should conduct unbiased, thorough investigations that consider the facts, rights, and emotions of all parties involved. Maintain confidentiality to the extent possible, but you may not require either the complainant or the witness to maintain confidentiality under all circumstances. Your company should protect the confidentiality of employees reporting suspected violations to the extent possible consistent with the investigation. However, under the National Labor Relations Act, you may not be able to require that non-supervisory employees maintain the same level of confidentiality. Information about an investigation should only be provided to those who need to know. Retaliation. Many employees who file discrimination and harassment claims say they were also victims of retaliation. The EEOC defines retaliation for purposes of the anti-discrimination laws they enforce as an adverse action against an employee or applicant because he or she complained about unlawful discrimination or harassment or participated in a legal proceeding. For an employee to file a claim of retaliation, the employee must show that they made a complaint about a practice or policy made unlawful by the anti-discrimination statute, or they participated in an EEOC investigation or legal proceeding and that adverse action was taken against them because of it. The EEOC defines an adverse action to be any adverse treatment that is based on a retaliatory motive and is reasonably likely to deter an employee from complaining about unlawful conduct or participating in a proceeding. Examples of adverse employment actions that might constitute retaliation are termination, threat, poor evaluation, demotion, moving work schedules or location, increased monitoring, reduction in salary or hours. All of the anti-discrimination laws enforced by the EEOC have protections against retaliation. What can employers do to help prevent retaliation? You should treat employees who have made harassment complaints the same as you would have treated them if they hadn't made a complaint. Employers, supervisors, and managers may be held liable for retaliation and subject to compensatory and punitive damages. Best practices to help reduce exposure to retaliation claims include know and adhere to your policies against harassment, discrimination, and retaliation in the workplace. Provide training for employees on your policies and complaint procedures. Treat employees fairly and consistently. In summary, every employee is responsible for their own personal conduct. This includes conducting yourself and treating others with dignity and respect. Actions and words that make others feel unsafe are not appropriate behaviors in the workplace. Every employer, regardless of size, should have a harassment prevention program in place to help shield employees from physical and emotional harm, minimize exposure to legal action, and protect the company's reputation. As a manager or supervisor, you have an obligation to support your company's harassment prevention programs, but this involves more than support for the policy. As an employee, you have an obligation to create an environment that is respectful to everyone. You control your environment. During this seminar, you've learned about discrimination, harassment, state and federal laws that prohibit such behavior, and your responsibility as a manager or supervisor to support and enforce your company's harassment prevention program. Being mindful of your company's program helps you recognize inappropriate behavior and potential harassment situations, take steps to avoid it, and take action to manage it. By being aware and responsible, you will do your part in supporting a harassment-free environment. As an employee, you have an obligation to support your company's harassment prevention program. There are some additional resources, and we're here to help. Paychecks.com is a source of information. Paychecks Work includes detailed articles on topics of interest for small businesses, and your dedicated Paychecks professional is available to help you. Thank you. We appreciate your time spent with us today for this presentation. And now I'm going to turn it back over for our question and answer period.
Okay, great. Thank you, Donna. We will now start the Q&A portion. I will read questions our participants have sent in, and we will address as many as possible in the time remaining. Please continue to add your questions in the Q&A box on the left side. If we don't have time to get to your question, I encourage you to connect with the SCORE mentor in the mentoring hall after the webinar. So let's get started. The first question comes from Joelle. What are the minimum policies small businesses should have in place?
I'll take that one. So the minimum policy is having a policy. Most states provide some pretty good guidelines to employers on what a policy should look like. So I would refer you to either work with your HR professional or to view some of those state websites that would give you basically the basics of what you need to have in a policy. One of the key elements of those policies is making sure that employees know exactly who to go to discuss their concerns.
I would also add that even as a small business, you could still have an employee handbook in place that you could include the policy and the process for handling complaints, particularly for your supervisors. But this way you would disseminate it in writing and they would sign off that they've received the policy and understand the policy. And also you could incorporate the policy as part of the training.
Okay, this is kind of an extension of that. A question from Denise. If a business has 5 employees and a contractor, do these
your employees should be protected from people in their, coworkers and colleagues and anybody coming in or out of the business. So if you had a delivery person, let's say, who comes in and that delivery person feels that they were harassed or that a hostile work environment exists when they go into your workplace, you do have an obligation to, create an environment or investigate that situation and deal with it and make sure that people coming into your office or leaving your office feel that they've been treated in a fair manner as well.
Okay, Yolanda asks, what are your thoughts on having a third party perform investigations of discrimination or harassment complaints in a company?
Generally, it's something that is done internally. There are some businesses that do work with employment attorneys who, are specifically trained in dealing with these situations. We often, as Paychecks consultants, we work with our clients on best practices around investigations, but because we're not employees of the company itself, we can't make those types of, we can't do those types of investigations or decisions. So I think they're best handled in-house You would just need to be sure that your in-house representatives are properly trained in conducting that investigation.
Yeah, I'd like to add that in Paytex, we offer, as human resource consultants, we offer our clients, we have an investigation seminar to kind of provide some training and best practices, as Donna mentioned, for conducting a workplace investigation. But a best practice is to, do it in-house. Like I said, we have those trainings in place as well. So.
Okay, Marta asked, how long can time pass from filing a complaint? So I guess how long can you wait? Basically, she had complained of a hostile working environment 10 years ago, and she reported it to HR.
I mean, 10 years ago is a long time, but as we're seeing now in the general environment that we're living in, I mean, there are a lot of complaints that are coming from many, many years ago. The thing that employers need to be aware of is if they're made aware of something, they have a duty to act quickly. The recommendation from once you know about something is to wait no longer than 2 days to get that investigation started and moving. But, certainly what affects your work environment, whether it was a long time ago or whether it's here and now, needs to be investigated and addressed.
Okay, next question is from Evelyn. I own a nonprofit women's advocacy program. Is it discrimination if I only hire or accept women and not men for these positions?
It is an interesting question. I would say that if an applicant is a qualified applicant and a male applicant, I think you would have to have a fairly compelling reason. That's something that, because it is so unique, I would encourage a business to speak with an employment attorney so that they are best protected, by making those types of hiring decisions. That is something that I think would require a legal review.
Okay, and Joseph asks, what ways can I bring awareness to this issue without targeting anyone?
I think what do the awareness is you can do what we call best practices of awareness training. And you offer it to the entire organization, and then you're not looking as being discriminatory, and also you would start with a policy and have a policy in place, and then conduct the training across the organization and present that policy. That is something that we do with Paytex. We train all the employers, we train the managers and supervisors, and you want to be proactive. So you could be consistently provide the training, and then you can do it on an annual basis, and then you're not singling any person out.
Another thing to tag on what Lowell just said, that we do two different trainings. We usually work with the managers and supervisors first so that they can take an internal look at, what their departments are doing, how their employees are acting, and then we would present it to the employees. So having managers and supervisors get the information first so that you can do a little internal housekeeping prior to putting it out in front of the employees may help not raise some red flags to your employees if that's what you've got some concerns about.
Okay, Sharice asks, what do you do with the person who is being accused? Would you put that person on paid leave until the matter is resolved?
It depends on the type of employee that it is. Under the Fair Labor Standards Act, you have exempt and non-exempt employees. So exempt employees may be treated differently. If you were doing an investigation and you felt that the behavior was egregious enough that you needed to put people out on leave, so it depends on their employment status, and you've got to be careful around that. So that's something that it would be very dependent on each situation and in the egregiousness of the complaint.
Okay, Elena asks, as human resource consultants, what is the #1 harassment or discrimination problem you consistently see in the workplace? And why do you think that is?
I will say it as an HR professional for the last 20 years, there's nothing that's particularly consistent about it. Lowell and I, will often chat, and there's a new story every day. But I think the best thing to do is to remind employees that your business is committed to a harassment-free environment, and that you take any allegation or complaint seriously, will investigate it, and that you assure no retaliation. The stories change, so everybody is unique. Everybody is just a little bit different. So there are a million stories, but employers.
Yeah,
an open door. Go ahead, Lowell. I'm sorry.
I agree. I don't think there's one thing that comes to the surface day in and day out. It's just something is it's there. It's a different situation. Every situation is different, and it affects every organization differently. And best practice is to be proactive, and as Donna said, bring awareness to that you have zero tolerance for such for harassment or hostile work environment, because at the end of the day, you just don't know. And sometimes if you bring this awareness to your employees and managers and supervisors, then hopefully it doesn't happen. But I don't think there is one thing that is at the pinnacle of harassment or discrimination.
Okay, Brian asks, a lot of subject matter applies to more of a corporate environment. And as a small business owner of a restaurant, I'm most concerned about harassment between employees and will not have a human resource manager other than myself. So how best can he design a handbook and complaint procedures?
So it would be the same as any other business. Whether you are a small employer or a larger employer, you would need to make sure that you as the business owner, and then your managers, your supervisors, are properly trained on recognizing or handling complaints when they're brought in, and how to conduct investigations. So as long as the environment is such that you have an open door and that people will come to you with those questions or concerns that they may have, that's the best way to handle it. And again, to have a policy, and to post the posters in conspicuous places where employees may, get information from them. I think those are your best tools to provide to your team so that they know who to go to.
And I'd like to add, we have many clients that are small business owners, restaurants, doctor's offices, different dental offices, so we can assist with that, and typically that's what we do. We help develop these things too. So as Donna said, it doesn't the rules as far as trying to prevent it and being proactive and having best practices in place. It doesn't matter small, medium, large. The process is going to be the same. You want to have like Donna said, an open door policy where you want the employees to come forth if there's a situation, and you want to be able to address it accordingly and do an investigation if need be. So it doesn't matter the size, but again, we have all different employee count clients. So I think it's just trying to be proactive and bringing awareness to it and, addressing issues as they come up.
Okay, Alexis asks, what do you suggest the policy should be for employees who are harassed by the company's clients? They provide services in clients' homes, and should the company take similar steps as if the employees were harassed by their supervisor?
So I would say yes, that, if your employees are going out to clients' homes or other businesses, you still have to offer them a hostile, or harassment-free work environment. And if one of your staff members does come back and say, they had a situation with a particular client, it needs to be addressed. It does need to be addressed. And if it's one business owner talking to another, or whoever the service provider may be, to say this is the situation, it does need to be addressed and it does need to be corrected. It is challenging when you. Oh, go ahead.
Go ahead, Donna. Go ahead.
Well, it is challenging for a lot of environments where, if you're a healthcare provider and you're going out to a patient's home, or, it may provide some unique challenges, but you do have an obligation to protect your employee.
Yeah, I'd like to say, discrimination, harassment has no boundaries. So many, businesses do work in off-site locations and stuff. And I think the best practice is the same process and policies you have in place for this should go to out to the clients that you're doing business with. It's the same thing as if they're coming into your establishment. Just because they're not under your roof does not mean that they don't have to adhere to your policies and processes that you have in place. Again, we mentioned in the presentation, all employees have the right to feel comfortable in the workplace. And whether it's on-site, off-site, I think it's holds true. So I would agree with Donna and saying, yes, they should have the process be the same.
Okay, next question. What if you submitted a complaint against a supervisor who is the relative of the human resources director? How can this be addressed?
I mean, it still should be brought forth to the people that are in charge. I mean, typically, non-harassment policies designate individuals that employees can go to, or they often will say any other member of management that you feel comfortable going to. And your entire management and supervisory team should have training and knowledge of how to handle these claims. There's always very touchy situations, but certainly sounds like one of them. It still needs to be addressed. It still needs to be, the individual needs to be afforded no retaliation. And that's something that, business owners and leaders need to be very aware of when they have these types of family relationships or, individuals that may be related working in those types of close situations. So it still needs to be brought forth and still needs to be addressed.
Okay, next question. In a nonprofit environment where a member of the board of directors may be the harasser, thoughts on how a policy might look to include protocol where the board of directors is concerned?
A policy is for the entire organization, so it doesn't. I think and with the question, everyone is held accountable to their behavior. So in the policy and procedures, that is why you have a policy. So it doesn't disseminate, this can't be or that can't be. The policy is there And again, getting back kind of to the prior question, it's no retaliation. So, these things in organizations are to protect all parties involved.
Okay, next question is, what if you're a supervisor and an employee reports harassment to you? You report it to your superior, but they failed to report.
So I would assume that you mean they failed to investigate. It needs to go further. So if that supervisor or manager who was responsible for handling that is not doing it, then it needs to go to the next level. I mean, if it needs to go all the way up to the business owner, the CEO, the president of the corporation, it needs to be addressed. So if you've had a complaint, you've taken it to where you have been directed to, and it's not being addressed, it needs to keep going. It needs to keep going. And if it doesn't, I mean, an individual can then go outside of the company. And what your goal is to try to deal with things internally, because once you get an outside agency coming in your door, they're not only looking at this situation, but they're going to be looking for other employment practices and things like that. So, it is very important, although an individual does have a right to go to any outside agency like the EEOC or a state agency, you want employees to minimize the business's exposure. You want them to understand that this is how things are handled here, and this is how we will address and take action.
Okay. Would this be considered discrimination if you're sent to a certain area on a continual basis only because you are of the same culture and you were told that you would do better there?
And that's seeking, I think, a legal opinion on something. It depends on if it's a certain territory that you were hired into. There's a number of other factors involved there, but I think an individual, may need to connect with somebody for a better definition of that, when we're not qualified to really answer that question.
Okay, sexual harassment happens in the workplace often. In government agencies, obviously training is mandatory. However, I've seen people walk out joking about the training, and when you add contractors to the equation, this makes them more fearful because of retaliation. How do we make the contractors feel more confident in the policies?
I think you need to, have the policy and practices in place, and I think that should be addressed. If people are commenting after the training and stuff, then that needs to be addressed in a, kind of like right away, because if you're not addressing it, then you're kind of going through the training as just kind of going through the process. But if others, again, everyone should feel comfortable in the workplace, whether it's the training that's taking place or, the day-to-day. So I think that needs to be addressed so that everyone is feeling comfortable, not feeling that, it's a joke. All parties should really take it serious. And as an organization, they should do that.
And the policy, just to key off of that, needs to be enforced consistently among everybody associated with the organization.
Okay, great. Well, those are all the questions we have time for today. Please enjoy the rest of the virtual conference. You can talk to a mentor in the mentoring hall, network with other business owners in the networking lounge, and chat with industry experts, and pick up free business resources in the exhibit hall. You can also join us for the next webinar, Get New and Repeat Business on Autopilot with Email Marketing, which starts at 4 Eastern. We will also have more webinars Wednesday and Thursday. And on behalf of SCORE, the SBA, and Paychecks, I'd like to thank you all for attending this webinar. And a big thank you to Donna Denoyle and Lowell Woodcock for presenting today.
Thank you.
Thank you, everyone. Have a great rest of your day.
All right. So that was that. Once again, sorry for the late, the delay in getting that going. But you are tuned into TRUthe Media, ladies and gentlemen, and where we are attending here live today is it is National Small Business Week. That is the virtual conference. So I'm bringing you all, my people, in on the virtual conference. That is just like when you pay to fly and attend conferences. This is doing that virtually. So I'm on here literally connecting, with other businesses. I've also been promoting my business and connecting with other women entrepreneurs and people of color entrepreneurs. I've been in the mentoring hall, the networking lounges. There's a help desk, and there's all these things you can do even to get points. I'm looking at the scoreboard. People are getting points for the activity that they are doing, like going and promoting the event online, as well as visiting other businesses, and we're networking with one another, sending one another messages and notices. All of that is gaining points. And there's rewards. Like once we reach a certain level, we can get rewards and win certain items. So I am excited about that. Right now I have 830 points. No, wait. Yeah. I'm ranked like I'm not even gonna say my rank right now, but that is what it is. So this is it's something to do, it's something fun. It's a way for me to focus on my business, focus on building my business and seeing what else is out there, and a way for me to promote with my peers, with other entrepreneurs, with other businesses, with other small businesses in the United States of America. So this is highly sponsored and heavily sponsored by the SBA, which is the Small Business Administration here in the U.S., and SCORE. SCORE is a program, a nonprofit program association dedicated to helping small businesses get off the ground, grow, and achieve their goals through education and mentorship. Okay, that is SCORE, SCORE. This is sponsored by, the gold sponsor is Visa. You know who that is. And then Google is a silver sponsor. Square is a silver sponsor. Chase for Business is a silver sponsor. Constant Contact is also a silver sponsor. I see some names here as bronze sponsors, not really familiar with them, but if I'm going to learn today, I guess. So there's TRUthe, that's spelled THRYV. And again, folks, I am not from these businesses. I am not a representative of them. This is just my video blog and my podcast and my direct contact to my community and my network of people, to share the information that I have as I continue to build community and build business and eradicate poverty, homelessness, houselessness, hopelessness, right? So, and I'm doing that all through hip hop education. So here's TRUthe. TRUthe is an all-in-one management software. Of course, they will be doing, landscaping right now. But all-in-one management software built for small business. That's TRUthe. Lockheed Martin is also a bronze sponsor. Who are they headquartered in Bethesda, Maryland. Lockheed Martin is a global security and aerospace company. Okay. National Association for the Government Guaranteed Lenders. That's NAGGL. That's also a bronze sponsor. They serve the needs and represent the interests of the SBA lending community as they finance a wide variety of Main Street small businesses. through SBA primary loans. Okay. All right. UPS. So that's financial, but it looks like it's government ran. Um, at least, right? So UPS is also a bronze sponsor. We know who UPS is. Raytheon is also a bronze sponsor. For those who don't know, it's 217 sales of $25 billion and 664,000 employees. Headquartered in Waltham, Massachusetts, a technology and innovation leader specializing in defense, civil government, and cybersecurity solutions. Okay, Verizon. Um, we know who Verizon is, right? Bronze sponsors. Salesforce for small business can help you find customers, win their business, and keep them happy to grow faster than ever. And we have Facebook Blueprint. It's also a bronze sponsor. This is important to know. This is actually interesting to know. Our mission at Facebook is to build community and bring the world closer together. This includes connecting the people who run businesses with the people who love them. This is Facebook Blueprint. They are also a bronze sponsor. Main Street Hub. Main Street Hub, a marketing platform for local businesses. Check out our resources on social media, email marketing, and reputation management, and learn why we're trusted by 10,000 small businesses across the country to tell their stories online. That is the Main Street Hub, bronze sponsor. I'm going to be looking all of these cats up for sure. And then Comcast Business. Welcome to Comcast Business. We provide solutions and resources to support small businesses and help them stay connected to their customers, community, and each other. I believe there's more. I don't know why I can't scroll down though. I definitely see more like Kimco, QuickBooks, Vistaprint. I don't know why I can't scroll down, but it's not letting me scroll down. See if I can do that. Maybe that'll work. Anyway, so that is what it is. The next seminar will be beginning in about 20 minutes. Excuse me, 20 minutes. And I have some things I need to do, but I want to quickly run this through so you guys can. Let me go to the mentoring call, see what's in here. Oh, okay. Get free business advice from Score Mentors. Click on a business topic and get started. Marketing and sales, breakout rooms, business plan, and startup strategy, management, and finance. Okay. Let's go to the networking lounge. I can also watch tutorials, download the agenda of the next seminar and all of that, just like you would get certain things at an actual conference. This is me kind of, walking around, checking things out. So I went on and got some points. So let me go. I'm in the networking lounge, general introductions. People are just saying, hey, checking in. Already went to the women-owned business. Let me go to government contracting. Okay. Free webinar on how to land government contracts next week. Okay, there's a webinar next week. SCORE is doing on becoming a certified government contractor. So thanks for that note for the person who posted that in that room. And then solopreneur, self-employed. Let's see what that's about. Okay, so people are just posting their businesses and stuff like that. So I'm gonna look around a little bit, go back to the lobby, see what's what, and just head into some different spots until we start this next webinar. This next one is the one that's important to me. It starts in 13 minutes. 13 minutes to extra 5 will be 18 minutes. So yeah, it starts in just under 18 minutes. And it is by Constant Contact, and it says get new and repeat business on autopilot with email marketing. Your business thrives on bringing in sales from new and existing customers. In this session, you'll learn how to turn more website visitors into email contacts, how to automate timely engagement with new contacts, and more. So there we are. All right, so I'll be right back, folks. Again, this is TRUthe Media. Thank you for tuning in with us. Thank you for listening in with us and just being a part of our network. Whether you're listening to this live right now, whether you're listening to this later on today, or whether you're listening to this 10 years into the future. I appreciate the opportunity to put something in the historical archive, and I will be back to service you once again pretty soon. Peace and blessings. And